The Oxford Internet Institute's Colloquia. My name is Taha Yasseri. I'm a Senior Research Fellow here at the OII and the convener of the OII Colloquia. The Colloquia bring distinguished speakers from all around the world to the Oxford Internet Institute to spark conversation around the Internet and society. The word colloquia, singular colloquia, comes from the Latin word colloqui, which means conversation. Today we use the word to basically describe departmental seminars that are general, both in the sense of topics and the audience. However, our colloquia come closer to the original sense of the word. That means that through this series of events, we aim to interact and initiate conversations and strengthen our ties to other scholars who are studying internet and topics related to that. The colloquia should be considered as a trigger for long-lasting collaborations between the OII and the speakers. We have 2 events per term, weeks 2 and 7 on Thursdays from 5 to 7. Well, with that, I'd like to ask my colleague, Dr. Katrin Eccles, to introduce the speakers of tonight.
Welcome, everybody. It's a huge pleasure this evening to introduce Professor Karen Yeung and Professor Timothy Endicott, who are going to be speaking to what's wrong with using machine learning to personalise law. This combined presentation is a sort of response to the increasing automation and power of machine learning in legal services and legal practice. And in this paper, they'll be considering claims made by those who believe that such a move towards automation, to personalising law, would enhance the administration of contemporary legal systems. They'll be introducing some problematic turns in this environment. So to introduce our wonderful speakers this evening, Professor Karen Yeung comes to us from a very recent move to the Birmingham Law School and School of Computer Science, where she's recently taken up a new interdisciplinary post, a professorial fellowship in law, ethics and informatics. Really a true collaboration between the School of Law and the School of Computer Science. It's a really exciting new sort of role, I think, and it's wonderful to see these two fields working so closely together. Karen came to the UK from Australia in 1993 as a Rhodes Scholar to read for a Bachelor of Civil Law here in Oxford. She spent 10 years as a university lecturer in Oxford as a Fellow of St Anne's College, before taking up a chair in law at King's College London to help establish the Centre for Technology, Law and Society, TLOS, of which she was director from 2012 to the end of 2017. Her research expertise lies in the regulation and governance of emerging technologies, and her more recent and ongoing work focuses on the legal, ethical, social and democratic implications of a suite of technologies associated with automation and the computational turn. Her work has been at the forefront of nurturing law, regulation and technology as a subfield of legal and interdisciplinary scholarship. She is really keen to foster collaboration between academics and policymakers. She chairs the Nuffield Council on Bioethics Working Party on Human Reproductive Applications. And she brings together policymakers and academics from various disciplines concerned with examining the social, legal, democratic and ethical implications of technological development. So she's a really true interdisciplinary scholar, which is what we like here at the OII. Our wonderful Oxford colleague, Timothy Endicott, has been a Professor of Legal Philosophy since 2006 and a Fellow of Law at Balliol College since 1999. He served as the Dean of Faculty of Law for 2 terms from 2017 to 2015. That's quite the sentence. He writes on jurisprudence, constitutional and administrative law with special interests in law, language and interpretation. He's the author of Vagueness in Law and Administrative Law. He graduated with an AB in Classics and English from Harvard, another humanist gone bad. Studied law at the University of Toronto, practiced as a lawyer in Toronto before returning to us in Oxford in 1998, graduating with a DPhil in 1998. He's been the general editor of the Oxford Journal of Legal Studies since 2015, a journal that celebrates itself as a forum for outstanding contributions to legal studies with an emphasis on interdisciplinarity, so a meeting point between law and other disciplines. So another true interdisciplinary scholar. Welcome to you both. Thank you so much for joining us, and I'll ask Karen to begin. Thank you.
Thank you, Catherine, very much for that very kind introduction. I'm just hoping that this clicker works, and I have to stand somewhere where I can see the slides. So I hope, can everybody hear me? Can you hear me up the back? Great. So it's a particular pleasure for me to be here because, as Catherine mentioned, I actually started off my academic life here in Oxford over 20 years ago now, so that's kind of showing my age. And it's a particular pleasure for two reasons. Firstly, I remember when the OII was set up, because I was here at that stage, and I remember actually Jonathan Zittrain gave a presentation for my students, my BCL students, and he said to them, he said, "Who here has heard of Facebook?" And only one of my students had even heard of Facebook. So that just shows how far we've come. And secondly, when I first came, Timothy in fact filled in for me before I started because I wanted to finish my articles in Australia. And so in fact my friendship with Timothy goes back over 20 years, and this is the very first time we have actually written an academic paper together. So it's a double pleasure. It should come with a big warning, and that is this is not a paper, as in it doesn't, the thoughts that we're going to throw out are not sufficiently formed to constitute a paper, and it's very much a work in progress. So I do hope that there's lots of opportunity for you to feedback and to throw around some ideas to help us try and get to the heart of what some of the questions are here.
Could you have a quick pause? We have one more audience
Oh,
to join
sure,
us.
of course. Sorry.
Thank you very much.
That's okay. So the title of our presentation is "What's Wrong with Using Machine Learning to Personalise the Law?" And as Catherine already mentioned, you've heard all of the tropes about how AI is disrupting every industry that you can mention, and there's a fourth industrial revolution, rah, 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 and the legal services industry is not immune from this. Okay, so one of the big topics of conversation, sit down and talk to the law firms in the city and elsewhere, is how is AI going to change the legal services industry? And of course there are concerns about jobs for lawyers, particularly for young lawyers. And that is an important question, but we're not going to focus on that today, okay? Because in fact we're not so much interested in the legal services industry, but a number of proposals that have been raised by various scholars, mostly from North America and Canada, who work in the law and economics tradition, who have suggested that we should use AI techniques, particularly applying machine learning to vast volumes of digital data, in order to personalise the law. So you can see an analogy here with the way in which search results are personalised, or product recommendations are personalised, or your Facebook newsfeed is personalised to fit your profile. And this is the kind of core idea that these proposals are recommending. And so we were interested in thinking about what are the implications of actually, if these were to in fact work themselves out and become systems in practice, what would be the implications for law, for legal systems and their legitimacy? So there's the disclaimer, highly preliminary, welcome your feedback. So just to give you an outline of what we're going to do, I'm going to give you a very potted summary of just a few of these academic articles that have emerged in recent years, and explain to you how they argue for legal personalisation, why they argue for legal personalisation, and then why are these proposals, in our view, problematic. So at that point I'm going to hand over to Timothy, and he's going to ask questions about, well, why do we actually govern social conduct through law? What is it that's distinctive about legal methods of governance? He's going to introduce constitutional considerations. Why don't we just replace tribunals and courts with machines? Does that sound like a good idea? And why not have something like your GPS, except instead of giving you directions to navigate the territory and space, it would help you to navigate your legal rights and obligations, constantly giving you updates about what you should do or what you could do to comply with your legal obligations. Would that be a good idea? And then I'm going to pick up on that and talk about problems with the principle of political equality that legal personalisation raises, the rule of law and the importance of reasons, the dangers of algorithmic decision-making systems in particular and their applications to law, and finally a wrap-up, which I deliberately didn't call a conclusion because we don't really have a conclusion yet. So on that note, let me start with different forms of legal personalisation that are emerging in these academic articles. So it's really important to clarify that I'm not saying these systems are currently in use. There are a couple of systems under development, particularly legal prediction systems, but the ones that, many of the ones that we focus on are simply purely academic. They're suggestions about what we might do with AI systems in relation to the law. And we can divide them broadly into two. So the first set seek to apply machine learning to vast volumes of digital data collected from our digital breadcrumbs in order to profile our behaviours, our preferences, our tastes, our cognitive abilities and so on, in order to personalise the content of our legal obligations and adapt those legal standards to our predicted personality traits and cognitive capacities. And the purpose of doing this would be to fill gaps in the law where parties haven't made explicit legal arrangements, to tailor the information disclosures that might be required when we're about to engage in some kind of transaction, and even to personalise the content of substantive legal duties and obligations. The second, and this is where we are seeing some systems starting to be rolled out in practice, is to use big data analytics, apply them to primary legal sources, so apply them to statutes and cases and guidance that's been issued by regulators in order to predict how the law might apply to a pre-identified set of facts. So these are the two different forms of legal personalisation that are emerging in the literature. I'm going to say just a little bit more about them so you get a flavour of what these kinds of proposals are about. The first one is by Porat and Strahilowitz in 2014. Personalising default rules and disclosure with big data. So the complaint here is that law is too impersonal, and they give an example of people who die without having made a will, and that's called if you die intestate, then the law prescribes certain default rules that apply because we have to do something with your property on death. And generally speaking, those laws are uniform for men and women if they die without a will. And they say, you know, this is problematic because actually if you look at the social scientific evidence, when a woman makes decisions about what she would like to do with her property on death, she prefers not to leave it to her surviving spouse. And that's because the surviving male spouse is much more likely to remarry and have further children, right? So she, quite sensibly, and I've done it myself, doesn't want the new wife and the new wife's children with her former spouse to inherit her property. Completely understandable. And so they say this is a bit rubbish, isn't it? The law shouldn't have uniform rules for men and women when they die without a will. So in other words, we should tailor the default rules to the circumstances of particular individuals. And here they just use a very rough guide of the differences in general between men and women and what they would prefer to happen to their estate on death. And they say, so we could apply that logic, but now that we have the power of big data analytics, we could have more than one variable that would determine what those personalised default obligations were, and we could make those legal defaults even more sensitive to your inferred preferences, your personality traits and your cognitive capacities. And so the core argument they make is that the law should set default rules across a range of legal contexts which are tailored to the personality characteristics and past behaviours of individuals, to infer their preferences and then tailor the legal rules accordingly. So they offer a number of contexts where they think this might be useful. So various kinds of contract, consumer contracts, landlord and tenant contracts, even employment contracts where the parties haven't actually expressly set out the terms of their agreement, then the defaults, they say, should be determined by these kinds of AI-driven personalisation techniques. You could also use these personalised legal defaults to fill gaps where there's failure to express the actual terms they wanted to govern their intentions, and even information disclosures might be personalised to the individual in question. So to give you an example, for those of you who are medical lawyers, and I meant to ask to see a show of hands of who was actually a lawyer, but there are certain obligations if you're about to go under the knife, okay, and there are risks associated with that particular treatment, then the clinician must disclose to you all of the risks associated with that procedure so that you can give your informed consent to the treatment. And one of the problems that Porat and Strahilowitz point out is that actually we have very, very different capacities to understand the complexity of information. And the same is true with financial disclosures and so on and so forth. So we should use big data-driven profiling techniques to work out how much information can you cope with. And so the simpleton would just get 2 sentences, and that would be okay. And the really sophisticated patient could get pages and pages of disclosure. So that's the core idea. That's how personalisation will work according to Porat and Strahilowitz. Philip Hacker, a German private lawyer, very similar kinds of proposals. Again, behavioural personalisation in legal contexts for various different kinds of contracts, a similar kind of information disclosure suggestion. He's even more ambitious. So he says that actually even more radically, if the big data tells us that some people are really bad at decision making and they commit themselves to contracts that are actually really bad for their own individual welfare, then perhaps we should actually impose legal constraints on their capacity to undertake certain kinds of transactions. So for example, you're not allowed to take out a loan that's more than a particular threshold because you make bad decisions. So the big data-driven personalised profiling will say, sorry, you can't have that kind of contract because that's contrary to your interests and there's nothing you can do. So you can already see that these are problematic in various ways. Even more ambitiously are recommendations that we should use big data-driven analytics to personalise the legal duty of care in negligence. And so the basic idea here, and you know when you go out onto the road and you're driving, you owe a duty of care to everybody on the road. So the standard that we operate, at least in British law, is a uniform or a relatively uniform objective reasonable person standard. You have to meet that standard in order to discharge your interpersonal obligations of care to other people that are using the road. But Shahir and Porat point out that actually some people are really fantastic drivers and they're very skilled, and some people are really unreliable and hopeless. And also some people are a bit clumsier than others and create more risks, and others are very, very careful. And so what we should do really is personalise the scope of your legal obligations to take care in relation to others and in relation to the risks that you generate for others. And so the result of applying big data-driven behavioural profiling would be that every individual would be legally required to meet her own customised standard of care based upon that particular individual's subjective skill level and their tendency to create risks. And this could be combined to form a composite personalised expected risk score. I kid you not, that's what they propose. It's a very long article, by the way. Okay, so those are the kind of behaviourally driven proposals. There's a second set of proposals about the way in which you would use AI to personalise the law, and this is more about legal prediction and advice systems. Okay, so a set of Canadians have written about self-driving laws, and they say what we should do instead is to apply machine learning algorithms to all this body of legal data, all of this case law, all of these statutes, etc., administrative guidance to predict how the law would apply to a particular set of pre-specified facts pertaining to any given individual. And so here, personalisation takes on a different guise. It takes the form of a prediction about how general standards of the law would be applied to the particular facts of that individual in order to generate personalised guidance to those seeking advice. So it's a bit like personalised nutritional guidance. You know, you should eat the following things, if this is your health goal, but except that if your goal is assumed to you want to comply with the law, so a personalised legal guide is provided to you. And their specific proposal is that we could start with regulators and administrative agencies that are required to enforce legal standards, and they would have a machine that churns out this advice. And if you wanted advice as to how to comply with the law in that particular domain, you could just enter in your fact situation and it would spit out a personalised micro-directive. And that would predict automatically how the law would apply to your situation. So why might this be a good idea? Why is it that these academics are so keen to embrace legal personalisation? Well, all of these proposals are trying to address a common problem, and that is the problem of uncertainty associated with the application of legal rules in particular cases. So we know that we have an obligation not to drive dangerously, for example, but what exactly does that mean? What does that require of us when we're out on the road? So one of the benefits of a much more fine-grained, personalised advice would be to give us much clearer guidance about what we should do to comply with the legal standard, and this would reduce the uncertainty associated with legal standards. And this uncertainty associated with legal standards arises because rules are inevitably imperfect. There are always going to be some cases that you want to catch that don't fall within the rule, and some cases that you catch within your rule that you didn't mean to catch. They're indeterminate. Situations can arise when we're not quite sure whether or not it fits our rule, and their interpretation is subject to a number of different meanings. And so this means that there is inevitable uncertainty in the law, And this uncertainty undermines the capacity of the law to provide guidance to us as to what we need to do to comply with the law. And it's also vulnerable to abuse by discretion, vulnerable to abuse of discretion by officials when they're applying those legal standards. So that takes us to the point of thinking about what is it that's problematic about this. I'm going to hand over to Timothy, but before I do, most of our analysis focuses on the question of personalisation per se. What's wrong with personalisation? Let's forget machines. And we start by just focusing on personalisation, and then we introduce the machines. And on that note, I'm going to hand over to Timothy. Thank you.
Thank you, Karen. Thank you, Catherine and Taha. This is terrifying. And I blame Karen. It's all her idea. And by terrifying, I mean, well, in two respects. What is some of the possibilities for using machine learning to govern a community are terrifying, and trying to form a sound judgment about something so complex is also terrifying. Partly because I don't know anything about the technology. I'm going to use big data analytics as a shorthand for that I hope is an acceptable shorthand for the process of using machine learning for the machine to identify patterns in a set of data, and then we're talking about how that can be used in legal regulation. And as Karen said, we're at the point where we want to express some of the possible disasters, or even just modest problems for a community that tries to use big data analytics in governance. And I'm going to focus on the importance of responsibility, the importance of personal responsibility, and the importance of the responsibility of public agencies. And responsibility, personal responsibility, isn't there an interesting sort of tension in the idea of personalization and the idea of the impersonal? And here's a lovely, that's the first sentence in this landmark article that Karen told you about. Law is impersonal, and it sounds bad, and I think it reflects that what these people are doing, and what some of the others that Karen has told you about are doing, is a project that is anti-law. Anti-law. And I want to emphasize that for myself, and I hesitate to speak for Karen, but I think that for Karen too, you'd probably agree with this, there's something to it. Because law is not everything, and law can be a really stupid way of organizing relations between persons, and even between state and individual in some respects. And Karen and I, as you can tell, we both think law is really important for the governance of the community, and it really isn't everything. And there are some potential huge improvements in risk management in the community through big data analytics that could be really useful and perfectly just and convenient. And so we're not against, or at least I'm not against, big data analytics in running a community. But there is an inescapable role for law in running a community. And by a community, I mean anything roughly like this, the United Kingdom. We need law. And so there are limits to the value of an anti-law project, and there is potential for it to be a destructive project. And I'll talk about the potential. Using, first of all, to illustrate a problem for personal responsibility, the problem that Karen mentioned, and this is a quote from that article. Remember, the problem is, if I don't write a will and I die, what should the community do about the resulting question of the allocation of the property that was mine before I died? Karen mentioned the gendered argument in that paper. We argue that as long as these preferences, remember, it's what Karen told you, the preferences of women to make sure that their property is allocated to the children of their marriage and not to the widower because of the prospect that he will go and have other children and dissipate the property in giving it to them. and the preferences of the man who's not that fussed. That's what they're talking about at this point. And I want to step beyond that. I'm not going to, if I had a will, I wouldn't tell you what it did. And I want to step beyond the gender, and let's totally personalize it. And let's say that the dearly beloved deceased person, they didn't write a will, but we've got their Facebook profile, and we've got everything else. And so we could do big data analytics to identify patterns in their preferences that indicate what their preferences were, probably, that they never expressed in a will. And the authors are suggesting that we could use that for this governance question in a community of what is to be done with the property that the deceased left behind. And they have a quite specific technique for doing this. You get guinea pigs, a group of people who have their own profiles, and you put all the profiles into the supercomputer, into the super data set run by the supercomputer. And you get the guinea pigs, it could be all of us or whatever, you probably need 50 or 60 people, but you wouldn't need more than that, to answer questionnaires about what their preferences, indicating what their preferences are, or would be if they were to die for the distribution of their property. And then you take the data set of the deceased and run the analytics on it, and you come up with a way of deciding what is to be done with the property. Now, look what we could get. More estate resources being allocated to heirs, according to decedents, the people who've died, true preferences. And I want you to stop and think about that. What they're proposing is that the question for try to avoid the word law, for the community, for governance, after the death is, what were the dead person's true preferences? And what I want to suggest is that that's a fundamental mistake about governance in a community. If you die without using a will, the question for the community should not be, what were your true preferences? The law of wills, of course, gives you an opportunity to act on your preferences and to order things for the future in a way that accords with your preferences. And it gives you the responsibility to do that, both the power and the responsibility, and enables you to do it. That's what the law of wills does, and you're responsible for exercising that, or not. You don't have to. And then, if you don't, what I propose is that the question now, how do we go forward in this community, is not what were his or her true preferences. So the task for the community on an intestacy is not to allocate resources according to the decedent's true preferences. That's up, and I'll come back to what responsibility requires in interpersonal relations. Here are the interpersonal relations between the person who died and his or her kids and partner and so on. We'll come back to what personal responsibility requires. Now, the public problem. Hate to hit you with another complex legal challenge. You're driving for Uber, and if you're an employee, it'll have implications for your tax position and your position in employment law and so on. And if you're an independent contractor, the consequences will be different. And this isn't just Uber, it's a long-running, hugely important problem for tax law and for employment law. How do we as a community decide whether a person is an employee or an independent contractor? We could just say, well, read the contract. If it says contract of employment, then you're an employee, and if it says contract with an independent contractor, well, of course, that rule of private law would empower employers and employees, and often the party to the contract who has the bargaining power, with the ability to manipulate the situation. So that's not what we do. We have a total relationship test. That's what they do in Ontario, where this article is based on Ontario, and they do something similar in every industrial community. A tribunal is going to have to look at all the facts at what the parties intended, but also the form of payment, opportunity to make profit, risk of making a loss, control over the person, whether the employer, if they are an employer, can tell the person not to work for anyone else, whether the person, the worker, has to work a certain number of hours, and so on. A whole set of considerations. And what Benjamin Allery has pointed out is that we can do big data analytics on what? On the body of decisions, hundreds or thousands made by the tribunal in question. Tax authorities, if we did the big data analytics on the decisions that have been made by the tribunal, and by the way, let's construct this exercise imagining that the tribunal is a good tribunal. Right? So start off being skeptical about machines and be sort of in favor of human beings. Go ahead. Imagine a really good employment tribunal full of human beings that's decided hundreds of cases. Well, with the analytics, the machine can predict, and they say in the article, I believe them, with great accuracy, 98% accuracy. I don't know how they arrived at the figure. 98% accuracy in the prediction of what the tribunal would say to the question, is this person in this situation an employee or an independent contractor? So do that, and then you've got a tool that tax authorities can use to be more confident about their ability to consistently and fairly administer differences of opinion involving the classification of workers. Judges could use this. If we did this, if we did the analytics, and the judges on the tribunal had access to it, they'd be all finished before lunchtime, and they could do other useful things. And Allery says that the technology is still got a long way to go, and it may be a while, maybe decades. He reckons it'll happen by 2075 that you could actually get rid of the tribunal altogether. And until then, judges could be using it. Judges could get the prediction from the machine, but they could they've got their experience, and they could spot points at which they want to disagree. But imagine, let's take a step forward and imagine we get to the point where we don't need the tribunal anymore, where the big data analytics can get to 99.5% or whatever it is that gives us confidence that the machine can tell us, is this an employment relationship or an independent contract? See, much sharper predictions about the content of standards in the law. But let's ask ourselves if it would be good not to treat those not merely as predictions, but as decisions, and replace the tribunal by the machine. Let me suggest some problems with this. One would be what we call ossification, a sort of paralysis in the development of the law. And there's a virtue in a human tribunal, which is that they can see what's stupid about the pattern, where instead of offering an analysis that is an interpretation and reflection of the pattern. So that's one potential problem. At the moment when we stop spending money on panel members and save a lot of money by sending them home and let the computer decide what counts as an employment relationship, that will be casting the law of employment in stone. That's one problem. There's a worse problem, I think, which is the unaccountability of the decision. The unaccountability of the decision and the unsurveyability of the decision. The machine would not be able to give reasons for decision. The machine would not be able to give reasons for decision. And I say that because of the assumption that it's not using a protocol, an algorithm to apply a rule. It's using an algorithm to identify patterns in a set of data. And there would be nothing that would count as an explanation for the decision. So it wouldn't be the rule of law And I think there's a need for the rule of law, especially in tax law, Now, let me pause parenthetically to point out why this isn't all crazy and isn't all bad. You might well say we don't have the rule of law today. They don't have the rule of law today in Toronto because they've got human beings applying the extraordinarily vague test of a total relationship in light of various different incommensurable criteria. And employees or independent contractors, whichever they are kind of at the mercy of the decision that's made by those human beings. And I think there's a lot of arbitrariness involved in that. And I think actually that and we're still working on this, I think I'd like to argue that those forms of arbitrariness are a price worth paying for a relationship between Uber and the driver and the community that is ruled by law. And ruled by law, of course, in a sense, it's not, because the vague test doesn't tell us, and what does tell us is whatever the oddbods on the tribunal decide. So it's ruled by them in a sense, but it's ruled by them in a way that reflects the rule of law virtues of a hearing with argument from each side, which you wouldn't get from an analysis of the data. And the independence in practice and, let's hope, in culture of the members of the tribunal, and their duty to give reasons for what they've decided. Now, those don't eliminate the arbitrariness of being subject to whatever decision they come up with on the tribunal. But they reflect an attempt to govern the relationship, not only between Uber and the person, but between the community and both of the parties in a way that's ruled by law. So, I'm sorry, did I forgot to click. That's the long quotation about the situation with employees and independent contractors. And the crucial part of it that I wanted to point out is much sharper predictions, and the possibility that we could move beyond much sharper predictions to precisified, personalized decisions based on the big data analytics. Okay, now I want to offer two legal principles. This is the principle of your and my responsibility in respect of the law. So it's a bit ambitious, and this is just a first crack at it. There is a principle that I want to articulate that concerns the way in which you and I and other individuals ought to have responsibility for what we decide. That would be violated, I think, by the big data approach to the intestacy problem, which is not based on the personal responsibility of the testator. And here's my crack at it. It's just as necessary for a community to hold people to be capable of and responsible for their intentional or unintentional omissions that affect the rights of others. And it is just as necessary for the community and other persons to give effect to those persons' actions in ordering their own affairs. The law is the community's technique for doing so. Affect the rights of others, that's just a sort of placeholder, and it's quite challenging, and I'm just beginning to work on it. To work out what it is for which you and I should be responsible and what we shouldn't be responsible for. If I lock my bike, I did lock my bike today, am I treating you as less than a responsible human being? Should I say, oh no, I mustn't lock my bike, because these people are human beings, they've got their own life to live, and here I am preventing them from doing something I should allow them to take responsibility for not stealing my bike. No. Locking your bike is not an infringement of the principle of responsibility of persons. And I'm still working on explaining why that is the case. But here's something that would be, something that I don't think Karen mentioned, that none of these authors mention, which is the Minority Report, right? Which is big data analytics to identify a high probability that you will steal my bike, and using it or kill me, and using it as a ground to lock you up to prevent your crime. None of the articles are identifying that as a policy proposal for personalization of law. Pre-crime, as it's called, the agency in the Minority Report that goes after you if you're going to kill someone. It's different because they don't use big data analytics in the Minority Report. They use precognition. So it would be even worse with big data analytics because of the uncertainty of predictions. So there's an example of an infringement of the principle of responsible personhood, as I call it, and I think that the law of wills is a way of respecting the principle of responsible personhood. And it's really important that I do it, that I sign the will in the form that's prescribed by law. And for those of you who aren't lawyers, I can tell you that in English law, if we've got my will already and my solicitor is coming up on the lift to get me to sign it, and I fall over dead, and there's perfectly cogent evidence that that is what I wanted to be done. Those are my true preferences. Irrelevant to what happens to my property if I don't actually sign it. And what I do, holding me responsible for what I do, and capable in what I do, is a crucial aspect of the responsibility that a person ought to have in the law. So that's you might call it the private one, but private and public get a bit complicated. And here's the one that you might call public. This really is public, and I'll explain why it's kind of complicated whether the first one is private or public. The principle of responsible government. This is easy. This is just how a community should be run. And here's the principle: government is for the good of the community. And by responsible, I mean it responds. The government responds to the relevant considerations. And it responds, and the relevant consideration, I think, is what's good for the community, and that good includes, and by the way, don't think, oh, he's a utilitarian, he thinks that if there's, no, that's, more happiness is not what's good for the community. What's good for the community is, first of all, what enables it to be a community. What enables it to be a community, and to act, to be a community and to act. And as soon as the community can act in relation with other persons, it's tied into the principle of responsible personhood. The community has to be a responsible person, and therefore potentially a claimant in tort against you or me, and potentially a defendant in tort at your claim or my claim. So that's why I said that the principle of responsible personhood isn't exactly a private principle. It is a private principle, but it also governs the relationship between the state and the individual. And it's part of the principle of responsible government, because people acting on behalf of us, if we've got responsible government, make the UK, and Oxford City Council for that matter, agencies that are legal persons. It would be radically unjust and abandonment of the rule of law if this community did not act as a legal person. So that's a crucial first step. There are other goods for a good community: securing responsible government through accountability. That's what we would lose. That's what we would lose if we had the machine learning decision on the employment case, because then your tax liability would be determined through an unaccountable process. The good of reciprocity between the governed and the government. That's an aspect of social justice, can be attained by democracy. I don't think it's actually an absolute rule that it can only be attained by democracy. I think democracy is the only way that's ever worked for attaining reciprocity between governed and government. And then I don't think there's any particular limit, because there isn't any particular limit to what you and I, as a community, could do in an organized way that needs action by the person that is our community, the legal person that is our community, to make things better, to make it enable us to be a good community together. So there you go. These principles are principles that will not be violated if we use big data analytics in governance in just and reasonable ways. And there are the principles that could be violated, depending on what we do. Karen?
That's me. Okay, thank you, Timothy. So you can see it turns out to be rather more complicated than it appears on its face. So I'm just going to wrap up now with a couple of additional concerns that actually feed in very nicely to the general principles that Timothy has stated, which kind of draw out this principle of responsibility a little bit more clearly. So one of the forms of arbitrariness that comes from having uniform standards is that actually we all have different capacities, and so that comes out in these proposals. And let's consider, for example, the fact that we have a fixed voting age. At 18 you become legally responsible for your actions and you are entitled to vote. Now the problem with having fixed voting ages is that actually people have very different levels of maturity and the capacity to actually understand the significance of their actions and to take responsibility for them. So why not have a variable voting age that is based upon some kind of test of maturity and competence to understand the significance of your actions? That would be feasible. There could be some kind of legal competence test that you would be required to sit prior to some kind of declaration that you now bear legal consequences for your action. But we don't do that. We set a very simple, clear standard. When you're 18, you become a legally competent adult. And there is a reason why we do that, even though we know that sometimes that will operate arbitrarily, that some people will have to take the consequences of their action, even though they don't actually have the emotional and mental competence to accept responsibility, because they've attained the age of 18. And there'll be some people who have the maturity to vote and take responsibility for their actions when they're less than 18. But we don't have a variable standard, and that is because we are committed in some circumstances to a principle of political equality. And so having a very clear fixed standard at 18, this fixed precise standard, even though it is imperfect, has an important expressive function, and it signals to the community that we are a community of equals, and that when you attain that age, that you are admitted into membership of that political community to which you are entitled respect for your preferences and considered to have the capacity to take responsibility for your actions and your decisions. And a further problem, of course, if we did in fact have some kind of legal competence test, is that it would be vulnerable to abuse by the officials who administer the test. So you can see that there are a number of reasons why a fixed voting age is in fact preferable, even though it is imperfect, because of this important commitment that law in a democratic community has to the principle of political equality, that we are all political and moral agents entitled to dignity and respect. But, and this is where Timothy and I struggle, it might not be so bad if we had a variable blood alcohol limit for when it was safe to drive under the influence of alcohol. Because some people can drive and tolerate more alcohol than other people, and so they can drive more safely on the road having drunk more than some people who are really very unsafe after only half a glass of alcohol. And maybe in that kind of context, it doesn't feel quite as objectionable to the fixed voting age or a variable voting age. And so it seems to us that that actually, in some cases, might be quite sensible. You could understand why we might have variable blood alcohol limits, because we could determine thresholds of safety in a way that was non-arbitrary, if you like. But the same is not true for the situation of voting ages. So thus far our critique is focused on why personalisation is itself problematic, and we haven't focused so much on why machine-based or machine learning-based personalisation is problematic. Timothy's also already mentioned is one of the main problems is that one of the important features of legal governance that distinguishes it from management is that, unlike your boss who says, just go and do it. Why? I don't care. Just go and do it. That's management. The law is not like that. And that is what makes the law distinctive. And it's important that the law provides us with reasons for actions. And if we have machine learning-based directives telling us what to do, that would be basically management and it wouldn't be the law. And this is because, unlike the old AI, okay, so the old AI systems were based on expert systems, which were basically decision trees based on particular sets of rules. You could explain why you got a particular outcome based upon the different rules that were applied, but it's not true of machine learning techniques because their outputs cannot be clearly explained on the basis of reasons. And Timothy's also explained that. You're probably familiar with all of the concerns that have been raised in critiques by a number of commentators about data-driven decision-making systems generally, and these apply with considerable force in the context of legal personalisation. So, for example, Bill Davidow, writing the Atlantic in 2014, warned that increasingly we see data-driven decision-making systems in a number of contexts, with the result that people are increasingly trapped in algorithmic prisons, he calls them, denied access to life-critical opportunities on the basis of their internet profiles. So they're denied access to finance, to education, to housing, to opportunities to board an aeroplane based upon these big data-driven analyses, which they have no access to, which are completely opaque and they are not given reasons for. And so this would be particularly problematic if the consequences are not just that you're denied a loan, but that it actually determines your legal rights and obligations. Then, of course, there are concerns about the data. How would we know? How would we have sufficient assurance about the data had integrity, that it was accurate, that it was representative of the population, that the training data you used was sufficiently representative? And this would be especially problematic for behavioural profiling. How do we know that the algorithms themselves were valid, whether they were free from discrimination and kept up to date and so forth? How would we know whether there were false positives and false negatives and that they were weeded out? Then, of course, there are problems of due process and fair procedure. If the machine issues a decision and all of the tribunal members don't need to be there anymore, what are you going to do about it if you're unhappy with the outcome? And, of course, all of this assumes ubiquitous and continuous surveillance of everything we do all of the time, with corresponding implications for privacy, autonomy, and freedom. So then, in closing, let's wrap up then. So our kind of core concern here is that it's possible to imagine a society that's incredibly efficiently governed by algorithms and data, where the optimization function is to maximize compliance with legal standards. It's possible theoretically to envisage that. And it might be incredibly efficient, but it wouldn't be a legal system of governance. And why is that? And the reason why, and Timothy has touched on this, is because the concept of law itself in modern legal orders requires adherence to certain basic institutional, structural and procedural qualities that are inextricably bound up with the modern conception of the rule of law and incorporated into the meaning of the law itself, which any kind of system of this kind would fail to demonstrate. So a system of governance that utilises AI decision-making systems to personalise the law and tailor it in these kinds of ways to fit the predicted behavioural characteristics and traits of individuals in particular circumstances wouldn't be a system of law. It would be a system of technological management and would fail to qualify as a legal system because it violates the rule of law and it fails to satisfy the requirements of the concept of law itself. So to sum it up then, we can see it in some of the precepts that we connect to and think are absolutely vital to what the rule of law ideal. And all modern conceptions of the rule of law emphasise the universality of the law's demands, that we expect laws to be framed in general terms, binding upon all members of society, however grand or lowly, rich or poor, intelligent or foolish, because that is central to the commitment of equality before the law. It's encapsulated in the maxim that justice is blind, and we see it symbolised in the figure of Lady Justice. She's an allegorical personification of the moral force of judicial systems, which feature a blindfold, and apparently since the 16th century, a balance and a sword, representing the law's impartiality, the ideal that justice should be applied without regard to wealth, power or other status. And it seems that the whole quest for personalisation runs utterly against the grain of law's generality and the universality which is fundamental to its legitimacy. Second, and again this comes out in Timothy's critique, is that modern legal systems are concerned to protect individual freedom by their commitment to freedom under the law. And freedom under the law is assured in modern legal systems by the provision of general, stable and publicly communicated legal rules which individuals can understand, reflect upon and apply to their own behaviour. And in doing so they stabilise their expectations about the law. And so it's true that there is uncertainty in how legal rules will be applied to any particular situation, and this is an unavoidable product of human language. It generates scope for interpretive discretion. It is vulnerable to abuse, but it does mean that it's up to legal subjects themselves to consider what the law means for them and what it requires for them. So as Jeremy Waldron points out, what is core to the law is its pervasive emphasis on self-application, which he regards as definitive and as established in the concept of law and is required by the rule of law ideal. He says anything that fails to treat individuals as responsible moral agents capable of understanding and following rules and answerable for their defaults does not qualify as law. And finally, law isn't just an exercise in efficient management. Law is a moral and normative enterprise. And this is where I think the law and economists sometimes misunderstand, that there's more than just organising ourselves efficiently. It provides an institutional framework through which a community of agents are held accountable and responsible to each other. That's reflected in the principles that Timothy has articulated. As Lon Fuller put it in his treatise on the morality of law, the enterprise of subjecting human conduct to the governance of rules involves a commitment to the view that man is or can become a responsible agent capable of understanding and following rules and answerable for his defaults. And this is reflected in the legal standards themselves, but it is also reflected in the institutions of our legal system and the procedures by which we hold people account for their compliance with the law, including the way in which we hold the state to account for its compliance with the law. And this is epitomised in the courtroom trial. So the trial process provides a formal opportunity for an explanatory dialogue, and I'm sure that you don't think of it like this, but actually that's what is going on, and that's why it must be public. That's why we believe in open justice. That's why we believe in the importance of legal advocates who can speak on behalf of those who are represented. It's an explanatory dialogue between a community of moral agents who hold each other to account through this constitutionally protected process in which the legal subject is called on to give an account of her behaviour to the community on the one hand, and the community of moral agents via these institutions on the other, either the judge or the jury, to evaluate and pass judgment on that account in accordance with law as a set of universal and general provisions that apply to all members of the community. And yet, in some circumstances, the classification of purposes for persons for legal purposes might be legitimate, and perhaps even in some circumstances, classification and personalisation undertaken by machine learning might be acceptable. And it seems for us that the challenge is to try to identify and articulate the conditions under which personalisation, including machine-driven personalisation, might be beneficial and consistent with the rule of law ideal. That's where we are. Thanks very much.
Right. Thank you. Thank you for sharing your ideas with us at such an early stage.
Yes,
because I think it's a really brave thing to have done and to express yourself so
brave.
clearly. I'm sure we have tons of questions.
Feedback, observations, anything. You're really very welcome.
Thank you.
Thanks for the presentation. I had some questions just to push a little bit on the point about the law obviously embodying the principle of need to provide reasons, and how machine learning algorithms in particular would struggle to do that because they're pattern recognition. And so if you take the case of most courts, except for apex courts, they are effectively, through the doctrine of precedent, at least in common law countries, largely looking for patterns of precedent and therefore consistency. And in particular, if you look at the role of advocates as almost basically trying to identify which facts are more or less relevant in pattern recognition, and then judges arguably basing their reasoning on which patterns exist. I'm just wondering if you see that.
Yeah, so you're absolutely right. So what does a court do when it's deciding how to apply this huge body of case law to your situation? And they do look for patterns, but they look for patterns in reasons. They don't look just for patterns in whether or not the defendant was wearing a pink cycle helmet. And this is the difference. Okay, so we look as lawyers for patterns in reasons because we want to give a reason why the law does or doesn't apply. So you're right, we categorise fact situations and say in this situation the person had more control over their workplace environment, etc. In these kind of cases, these criteria. So you're absolutely right. The process of legal reasoning looks for patterns in the reasoning, whereas machine learning algorithms simply look for patterns in all of the data.
Couldn't you just make the data that you put into the machine learning algorithm reasons as opposed to characteristics of a person or just pure outcomes?
Well, if you were doing that, then you're basically back on expert systems. You're trying to articulate a reason, and you wouldn't be using machine learning. So you could do it, and that's what the old AI legal systems tried to do, and they struggled because it was impossible precisely to articulate reasons.
And you could undoubtedly, for that problem about whether the Uber driver is an employee, you could have a sophisticated checklist, and you could have a complex checklist and a checklist system that was in which the conclusion was drawn by a machine on the basis of the entries, and then you'd be creating a rule, a complex rule for what counts as an employee, and that would be different from what they're proposing.
So just to give you, just to try and make that clearer, it turns out, for example, lots of employment sifting, so to sift people's CVs for whether or not you get offered an interview for a job, they found out, for example, that certain kinds of font are indicative of more likely success, and that for a lawyer is a totally arbitrary reason for selection, and that's because it works on pattern recognition. It's got nothing to do with your suitability as a candidate for success in this job. It just so happens that people who use that font tend to perform successfully and people who use the other are not, and that for us is an unacceptable reason for discriminating between candidates. Does that make it clear why, if you apply that approach to a huge corpus of legal sources, you get things like, people who drive red Mercedes-Benz are more likely to be employees? That, for us, totally arbitrary.
Sure. I just query
Yeah.
to what level you can tailor which patterns you're looking for in the data.
Yeah, I mean, I guess if theoretically you could somehow crystallise the reasons, like you could get the ratio of a case absolutely precise and then run it, it would be possible, but you and I know, if you're a lawyer, just how hard it is to actually come up with a uniform ratio of a case. People will have different interpretations.
I think the cool thing about the paper is really it's a case again. Like the core of the case is not really against machine learning. The core of the case is against personalization of law. Because I see
I think you're right.
Yeah, I see I come from U.S. context. I think data-driven approaches to measure gerrymandering that could really benefit from machine learning and simulating different types of political maps could be really useful for law.
Yep.
But for the personalization side, I'm curious to what extent have you considered existing elements of the law that are personalized, for example, sentencing regulations and guidelines,
Absolutely.
or even maybe a harder case that I haven't thought enough about that is how the law deals with people they deem mentally incompetent.
Exactly. So that's why we say in some cases classification of persons with different legal consequences is okay. So we don't treat children like adults. We don't treat them mentally incompetent like the legally competent. And we don't treat doctors, for example, in negligence cases like ordinary people. We hold them actually to a higher standard of care. And so this is the problem we have, that actually in some cases we accept that's okay and it is consistent with the rule of law. And the challenge for us in trying to articulate where are the boundaries of acceptable and unacceptable classification and stratification with legal consequences. I think your observation about the use of AI techniques for gathering evidence about the consequences of governmental interventions is absolutely spot on. I think there's fantastic opportunities to use these approaches for evidence-based policy and evidence-based legal reform, and I would be wholly in favour of that. It's the personalisation of legal standards that we object to, or that we're very cautious about.
I think sentencing is really interesting, and I haven't really thought about it. I wonder if the sentencing decision is, you might say, an executive decision on behalf of the community, but an executive decision that must be made by an independent tribunal. And it's a bit of a progress in this country getting past the point at which the Home Office can decide certain elements of sentencing. And that's a huge step forward. But what the judge is doing is not the same as what they're doing in the conviction for the armed robbery. Now they're deciding what is to be done.
Yeah.
And that might be a really challenging and interesting test for us. What about, because it's not irrelevant to the judge in a sentencing decision to ask about the future of this person, what they're going to do, and of course, as we know from the news, the parole board, when it comes to a parole decision, which is different again, really needs to be asking, right at the center of their attention, what is this person going to do? What do you think about using big data analytics to advise either a sentencing judge or a parole board as to what this person is likely to do in the future? That sounds to me a bit creepy, but I'm not sure.
Yeah, I mean, you're absolutely spot on, because once the decision of guilt has been made, then the court's decision is to personalise, is to come up with a personalised sentence. So their task is to apply legal standards to you, person who has violated the law. And you're absolutely right that sentencing decisions are shot through with arbitrariness. And so, in fact, there are systems that are being used to assist judges to make these kinds of decisions, not so much sentencing, but parole determinations in particular. They're hugely controversial for the kinds of reasons. But you can see the attractions of them. Oh yeah,
Are you serious?
they're serious. They're not using them in the UK, but they are using them in the US and other places. The UK, interestingly, interestingly, in the UK, they do use standard statistical regression analysis. But there is a big discretionary factor, and it's important for the Home Office that there is a big discretionary human factor. And the US, they don't preserve that, and they're much more willing to have these kinds of analytic techniques used to determine dangerousness in order to make release decisions. And so, in fact, they are being used in those contexts where the guilt determination has already been met, and it's about what happens to this individual offender. And that's one of the things I'm really interested in too. It's different from personalisation in this sense, but it is an application of AI techniques in law.
And so personalization has to be done. Is it okay to use machine learning in that context, do you think?
I mean, there's been a lot of evidence that existing methods to do the sentencing through machine learning re-entrench existing biases and have not been done well. But I think the broader point is, I think the paper, the only thing that you give to legal personalization advocates is they only want to reduce uncertainty, but I don't think that's true. I think the sentencing stuff shows that there is a broader potential benefit of legal personalization, which is almost like treating each person as a unique individual, and like there is this almost like
but that is a requirement of the principle of sentencing. That is what sentencing is for, is to make an individual determination of that person's sentence, which is different from what rules should apply to you when you're out driving your car. Or whether or not you can vote. In other words, what standards should you be held to account to? Very different from how long should you be shut up in prison. Yeah? But I think it's a good point.
Just on the sentencing point, I think that the problem with using machine learning even after guilt has been established is that machines don't understand context, which actually drives the major part of a jury's decision, which is even the most sophisticated machine learning system as of now can be very efficient in crunching data, but it cannot understand the difference between a play where somebody shoots somebody and an actual incident of that. I think that's the first problem. And the second is that machines can't understand mens rea.
Yes, absolutely.
Right? Especially when you're talking about criminal law. For something that's that's 50% of your decision, machines have no idea of how to go about it. And to compound that, even when you're setting, features for your machine to think about, or, when you're pushing so much data through a machine, you have no control over the proxies that it might catch on, which is the problem with the sentencing bit in the US, which is even if you say that you can't look at race, the machine looks at postcodes and makes decisions about your race, and hence it kind of entrenches these problems in also an invisible way, which I think is the actual problem.
Yeah, no, I agree with you. The point about mens rea, for those of you who are not lawyers, it means what is your intention? So there's a difference between intending to kill someone and not intending to kill someone in terms of the legal consequences. Even if you pull the trigger on the gun, how the law treats you depends upon what your intention was at the moment that you pulled the trigger on the gun. But actually, if you think about human decision making, we don't actually know what was going on inside that person's head. We actually have to make inferences about what's going on. We do make inferences because we weren't inside their head. So it's an interesting question about we infer from what's going on in the context about what was going on inside that person's head. And so you could imagine a machine inferring from the facts, which are not context, but the facts, what must have been going on. So actually maybe there's not as much difference between those two processes as we like to think there is, because I think you're right that we give meaning to sets of situations that machines obviously don't do, and a lot turns on how we interpret the significance of that meaning. And I guess the question is that really essential for certain kinds of legal tasks?
Karen, can I ask whether there's scope for big data analytics to improve our decision making as jury members? Because there are some areas of the law where conviction rates are very low, and we know that jury members are making imperfect decisions because of things like context that's consistently misread or misinterpreted because of societal norms that we want to dislodge. So is there a role there for big data to sort of steer us towards better decision making?
The trouble is, though, if those patterns of poor decision making are replicated in the corpus of decisions, then the big data will just replicate them.
Right.
Yeah, what's the data set? Is it like in what I described from this paper on the employment thing, where the data set is the facts and the decisions in all the previous cases? Then that we've got the danger Karen is talking about. Or do you mean some other data set?
Yeah,
I
that's
mean,
what kind of data?
So
To determine guilt? How,
So if there are a certain, if we know by reviewing cases that, objectively using the standards that we might want to impose on a jury, we would expect a different decision. Are there ways of working through those sorts of data to understand where we're getting it wrong because of human error?
I don't know the answer. I tell you what, actually, I think has got real potential is the use of augmented reality to correct the subconscious bias in jury determinations. It turns out to be actually incredibly good. Really good way of correcting for subconscious bias.
Wow.
And that could be really helpful, I think, for juries, rather than AI techniques.
Because then I suppose the legal responsibility and the legal action still rests with the individual,
Yes.
but we're being
Exactly.
educated. in
Yeah.
different ways.
Except the worries is, of course, that augmented reality is a form of brainwashing, so it's not straightforward either.
Gentleman back there has been waiting for a while.
I'm a bit uncomfortable with the idea of personalization being in the question, and it's because I agree that the law is always the law is impersonal, but it's always personalized in its application and its enforcement, right? And for example, even the example of the age, right, majority, we depend on technology to enforce that. And even for something as simple as age, we take that for granted. And for example, my great-grandmother, 100 years ago in rural Brazil, we could not apply this rule because there wasn't any way to determine when she was born. So I feel like part of the issue is addressing sort of this technological agency, recognizing this technological agency in legal decisions. And my question would be, what if we don't recognize this technological agency? What if we address the people that develop these technologies and make this an issue of incorporation of these techniques into law, into legal praxis, and maybe address a question of legitimacy, because when we're using algorithms to decide, these are procedures that were developed by someone. This someone, is it a private entity? Was there a legislative procedure in that gives this procedure, this technology, legitimacy in decision making? Anyway, it's a few comments that reflections that I had that I wanted to share.
I'm just struggling to get a grip on what it is that you're suggesting.
What did you mean by incorporation of these techniques? Can you give us an example of?
Because, well, when personalizing, what's an example you guys use? Personalizing alcohol consumption and driving, right? The issue there isn't, in my view, and it's not that there's a machine deciding, because this machine was devised and designed by humans, and whatever decisions it's going to make, a human conceived and encoded in that. What I see as a problem is that this process of determining what are the criteria is closed. It is not done through legislative mechanisms.
Yeah, okay, well, take the blood alcohol content limit that we have, is it 0.8?
I don't actually know what it is.
0.8 something in milliliters of blood in a liter of alcohol in a liter of blood, whatever it is, that adopted by legislation, very open, pretty useless to me as a driver, because I can't measure my own blood alcohol. But terrifically useful to us as a community, partly because we replace what we must have had before, which was, first of all, the police officer's impression as to whether I was too intoxicated to be driving, and then the dangers of the process by which the court convicting me of drink driving is assessing the credibility and judgment of the police officer. That's a mess. And it's so much better if the police can go to the court and say, here's the readout from the machine, and my lawyer can challenge the technology, but apart from that, if the machine works, I'm done. That's tremendously useful for us as a community, and it's fairly open, apart from the fact that I can't guide my conduct by it when I decide whether to get in the car. Now suppose we instead had a personalized analysis of the influence of alcohol on Timothy, and constructed a personalized limit. Would you think that would be all the better? Because the 0.8 thing, it's pretty arbitrary. Alcohol affects different people differently. What would you think about a personalized blood alcohol level?
My view is that we have a personalized, we have a breathalyzer that will be used on a certain, even, I admit it's rudimentary, it's a simple technology, but we will have a way of assessing how the individual is how
Right.
much.
But that's
he or she has
personalized
done.
in the same way that the law against murder is personalized.
Yeah, it's the same
right?
standard. It's not a variable standard. It's a fixed standard.
So it's personalized in the sense that I'll only be convicted of murder if the decision maker, the court, looks at Timothy and what Timothy did. But then they'll apply to that a general legal standard. Right? And likewise, if I'm charged with drink driving, they'll look at Timothy and what was going on in his bloodstream and apply a general legal standard that applies to generally. So it's not, the current blood alcohol content thing is not personalized in the sense in which we've been talking about it.
Sorry, I have a comment and question, might be related to what that gentleman suggests. I think it would be useful to separate automation and intelligence.
Yeah.
I think you used the word agency, which I think would do the same thing. I think you guys are fine with automation, but not with an intelligence. You know, if I have to analyze a very complicated text of contract to tick a very complicated checklist, I'm more than happy to delegate that to a machine. But if the machine is supposed to generate some information or some intelligence that is not in the contract, then probably that's where the problem appears. And in terms of the alcohol limits, it's very interesting because, well, I think as far as the law or the community concerns is the consequence of drinking alcohol. We put a limit on the level of alcohol measured through a certain way, which is translated to a number. For example, we won't ask people, oh, what have you been drinking? In that way, it's personalized because I might lose the alcohol in a way, in a very personal way, differently to Catherine. So we might show different numbers for the same amount of consumption. So in a way, it's personalized. But then, I think if we are using AI or any kind of automated system to measure the level of consciousness, we can set the rule there, we can give the same number to everyone, but then that would translate to different level of alcohol in different people. So in a way it's the same. So I was wondering why you are a bit uneasy about that.
Well, actually, that particular application is one where we think it might be okay, but we're struggling to articulate why. It's not like a voting age. The voting age would go, whoa, no. But when you say, it's like, well, the whole point of having rules about how we conduct ourselves on the roads is simply for safety.
We're not against, we're not against tests for a driving license, for
Yeah.
example.
So it's not, you know, regulating your safe conduct on the roads has really got nothing to do with political equality. It's about keeping us safe. And so variability doesn't have the same threats to kind of responsibility in political community. And so it might be okay, but what we haven't managed to do is really nail where the boundary is between acceptable variation in standards and unacceptable variation.
And we also, or at least I haven't worked out the difference between personalisation and management. And we're not against management.
Just don't call it law.
A huge step. It could be a huge step forward to replace to rebuild a 2-lane highway into a divided highway with a barrier down the middle, and then they're managing us, and I'm managing you if I lock my brake, and that's okay.
Yep.
The question is, where does
I mean,
management
I've been writing down the way in which design actually conditions and structures our behaviour, and you know, it's like, we think about raised footpaths, okay, so it protects pedestrians more because it makes it much harder for cars to mount the pavement. And so that's protective of the pedestrians through architectural design fiat, yeah? And it also means that it reduces the freedom of drivers to drive up in that space. I have absolutely no problem with that whatsoever.
And those forms of management, that's not personalisation.
No.
But personalisation can be a technique of management, is that?
It can be, but the worry is that if everything is managed, everything, so that all of your behaviour becomes technologically challenged in order to optimise some variable, safety, whatever, and we start to, that our freedom becomes increasingly eroded.
I'll tell you what I'm against.
At some point, it becomes a little dangerous.
I'm against you all know the pedestrian barriers that they have are between pavements and roads in some parts of this country. Not much in Oxford, but there are a lot of English cities where they're managing pedestrians by preventing them from walking
going
across
onto the road.
intersections.
Yeah.
And I find that slightly offensive.
That's interesting. That's interesting.
But that's not personalisation.
I'm okay with that.
That's not personalisation.
But that illustrates the tension that at some point you are eroding freedom by imposing some kind of technological solution, and sometimes that's okay. And to me, it's the creeping technologisation of managing behaviour that becomes problematic. If it becomes ubiquitous and pervasive, then I think we're starting to lose our autonomy, and that's a problem.
We'll take one more question, if that's okay.
I was just thinking of the management of that system. Have you given a thought of the costs of the personalising law? Who should bear the costs? Because one can argue that the law is imperfect, but it's actually economical, pretty effective in managing a large number of people rather than trying to personalise it and tailor it to a single application.
Yeah, that's a good point actually. It's quite, I mean, you know, it's a kind of slightly Foucauldian, is that you actually give the responsibility to individuals to work out how the law applies to them, and then they bear the costs of having to try and work that out. And so that might be collectively more cost efficient than having these kind of personalised standards. But I'm not an economist. I think you have to be an economist to try and model the relative costs.
I was just thinking if you came across some numbers or some discussions about that, because it's interesting.
I'd just be surprised if you could come up with really meaningful numbers.
You know,
But then I'm a skeptic about
some
numbers.
considerations that you should take
Yeah.
account by thinking about that system.
Yeah, I mean, I think that's a good, you know, actually thinking about the overall cost is definitely an important consideration too.
Yep.
It's
Very
not, it's
important.
not irrelevant at all.
Yep. Very important.
Okay, well, we have about 20 minutes with drinks outside, so I'll send you that way. But before you go, join me in thanking our speakers again, Professors. Thank you.